Hi and welcome to Hull and Hull TV. I'm Dana O'Brien and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, one common way of avoiding probate tax is setting up a joint account. Ian, help us weigh the advantages and drawbacks.
Well, it's a balancing act between convenience and control. And I always take the time with my clients to make sure they understand that while it is a lot more convenient to create a joint account and there may be tax savings, you are losing control of that asset in a very substantial way.
Suzana, how does the law apply to joint assets, particularly when a parent holds that joint asset with a son or daughter?
Well, we're fortunate that here in Canada we have the benefit of our highest courts ruling on that in the Picori decision, which tells us that when assets are held jointly with adult children and one of the parents dies, then there's going to be a presumption of resulting trust. And what that means is that the asset is going to actually revert back to the estate of the parent. And that comes as somewhat of a little bit of a surprise to some people who are more familiar with assets that are owned jointly passing by right of survivorship to the surviving individual.
Ian, let's talk about the importance of deeds of gift in avoiding disputes down the road.
Well, it is one of those little used but most effective tools that you can have in respect of giving something away during your lifetime that isn't real estate. We're very comfortable with signing deeds and having to pass on an asset in a formal way when it is something like a tangible asset like real estate. But if you're going to gift a substantial amount of money or a substantial gift of some sort, you can arrange with a good lawyer to have a deed of gift, which is a formal document to confirm the gift, and that has a very powerful impact when you die and makes the gift much more enforceable.
Suzana, are there other declarations of intention?
Well, there sure are. And as Ian said, the deed of gift is actually one of the best ways to document an intention to gift something. You can also gift, however, the right of survivorship, for instance, in a joint bank account or joint asset situation, or perhaps you might intend to actually create a trust arrangement. So even though assets are held jointly, they're still held in trust for perhaps other beneficiaries at the end of the day.
Ian, what's the best way of avoiding potential liability when planning a joint account?
Well, it is actually fairly simple. There are really two elements of a joint account that will survive and will pass as you hope to. The first element is write it down or have something in writing that identifies that your intention is A, B, or C. Whatever it is, whether it's to go to the child on your death, whether it's to go into your estate, somehow mark that down. And it doesn't have to be done in an overly formal way. And as Suzana mentioned, the Supreme Court of Canada recently came out with a decision that sort of said, look, just give us an idea. The other part of it is communicate that intention. If that intention is somehow documented and is meaningfully communicated, tell the kids, tell your lawyer, make sure it's somewhere in writing or has been said as well, then those two parts of it will make it an effective joint account pass as you intended, as opposed to as to how we're going to guess when you pass away.
So take out the guesswork. Ian and Suzana, thank you. And thanks for joining us on Hull and Hull TV.